I want to start with this quote here. In 2024, the workplace is experiencing significant transformation driven by technical advances, evolving societal expectations, and changing global dynamics. The biggest issue facing workers and employers today do reflect these ongoing shifts. Now, interestingly, this is what ChatGPT says about the biggest issues in employment law. And I want to assure you that we haven't planned all of today's session using Gen AI, but it was the first thing that came to mind for me when I thought about what issues are in the spotlight for us all. Across workplaces and most sectors, we are seeing artificial intelligence, and particularly Gen AI, and automation at an increasing rate. And of course, this represents huge opportunity. And I would say, do live in really exciting times. But from an employment law and privacy law perspective, there are, of course, issues to grapple with. Things like how can Gen AI help us as employers, but what are also the limitations and the potential risks? Jaya is going to speak in much more detail about that later this evening. But I will just say that Gen AI is also in the minds of the judiciary as well. We know that there's been a big guideline that was released just after our seminar last year to guide people who are going through the courts, using the courts, appearing before them on the use of Gen AI. And we know that our judges are also giving some thought to how Gen AI fits within our existing employment relations framework, even if we haven't yet seen the first big Gen AI case before the authority or the courts. Four other key issues came to mind for me when I thought about what we've seen this year. And I did consult my Gen AI tools, and somewhat interestingly and perhaps reassuringly, I will say that both ChatGPT and Copilot generated some lists for me, and these four issues were all included, whatever prompts I put in. So moving along to the first one. And that is working from home. Now, of course, when we were thrown into lockdown, a lot of workplaces were also thrown into to working from home arrangements also. And those arrangements stuck in one way or another for most. What's been really interesting this year, and perhaps surprising, is the movement away from those working from home arrangements. Working from home or remote working, we know, was commonly at the top of candidates' wish lists 2 to 3 years back. And now we've seen in that short space of time a cycle where we know that a lot of organisations, and we know the government, also making moves to change those working from home policies and putting constraints on how and when people work from home, and perhaps even moving back to the office full time. And that transition has been quite fraught, I would say. Many employees do feel strongly about their ability to work flexibly, work in a hybrid sort of arrangement. And we have seen a little bit of this transition generating, perhaps unintendedly, a lowering of morale and engagement on impacted employees. What we are also seeing, though, is employers grappling with the question of diversity and inclusion when they look at changing these policies. What remote working did for us is opened up to many employers access to employees that maybe might not have been able to participate in the workforce previously or had been underutilised. And so there are questions to be asked now, and things like, how might these changes of going back to the office impact those with carers' responsibilities or those with disabilities? How do employers ensure that they serve, or their remote working policies in their new form, serve organisational aims around D&I? And of course, how can employers then look at all that and at the same time ensure that they're meeting the changing needs of the business? The next issue that is front of mind for many is psychosocial risks. And what I mean by that is, as I'm sure you'll all know, those health and safety risks that arise from psychosocial hazards, being hazards that arise from how you work, who you work with, and where you work that may cause physical and or mental harm. Job demands, bullying, harassment, interpersonal relationships, culture. Now, interestingly, WorkSafe began consulting on some guidelines. At the end of last year, they were called the Mentally Healthy Work Good Practice Guidelines for Managing Psychosocial Risks at Work. They did the first round of consultation on those, and then feedback suggested that major changes were needed. So there's actually another round happening right now. Consultation does close on the 29th of November, so the end of this month. And I know that WorkSafe is particularly interested in hearing from small businesses. So that is something to have a look at if you want to have a say. Seems there are a number of factors, though, driving the impact of psychosocial risks and the increased impact of them. Lingering effects of the pandemic, those blurred lines, perhaps, and I've got up there on the slide, work hard anywhere where we think about working from home. The youth mental health crisis that we have in Aotearoa, hyperconnectivity from tech in our modern world, and of course the current economic strains. So we've certainly seen that our clients are dealing with increased concerns from their staff about psychosocial risk, whether that be as part of a standalone claim, or whether that's being raised as part of an ongoing process. We've seen a few cases before the courts. ICRA will shortly talk to us about the Susie Wiles case, which engaged in these issues. And also we did see the Cronin Lamp case, where a very sad case where those two school counsellors were actually awarded about $1.8 million collectively. That has been granted leave to appeal, though, so it's a bit of a watch this space. Next issue, restructuring. I don't really need to labour this point anymore, but we have seen this in the media, this increase of redundancies. We're certainly seeing it across our desks as well. And all I will say is that there were those two quite important cases from the Employment Court last year that talked about the good faith duties of the employer when they consult. Now, those cases didn't really change the law, but they just emphasise the importance of those duties, and that is front of mind for many of our clients when thinking about making changes. Of course, the other one is this ongoing discussion around employee status, who is an employee under Section 6 of the Act. And Peter will speak to this later this evening. He'll talk us through the Uber decision and the government intervention that is underway. And very quickly, before I leave you with Andrew, just a comment about what we're seeing through our employment institutions. We showed you this graph last year, and there's nothing much to say other than not much has really changed. Last year, we were looking at 677 cases in the authority as at the date of the seminar, 666 today, 190 last year, and 214 cases coming out of the Employment Court as at today. So not a much change in volume there. In terms of the matters that we're seeing really being brought through at first instance in the authority, a real mix, I would say. No particular theme, but there is that steady stream of redundancies being challenged, a number of claims around breach of records of settlement, and also a lot of claims where employees are saying that employers haven't paid contractual entitlements, which I think is quite an interesting one. And a very last comment, just to say, Section 123 payments, H&H, we're always interested in those. The median is still sitting around that 15 to 20k mark. That I would say is in line with the sort of gradual shift that we've had over recent years upwards, but perhaps not that sharp increase that you might have expected following the court's adjustment of the bands last year. So with that, I will leave you with Andrew to give you all an update on collective bargaining.
I'm going to be mercifully brief this year because really the big story in collective bargaining this year has been far and away just the story of CPI. Are you in charge? Oh. You look like you learned something. As you all know, the economy has just been on an incredible roller coaster over the last 4 years. In September 22, inflation peaked at about 7.2%. Even in September 23, it was still up at 5.6%, and trying to do settlements in that environment where nobody knew which direction CPI was going. But whatever you thought, you were looking at very big numbers and very big pay increases. That kind of created a series of short-term agreements because nobody could predict more than a year out. Nobody could even predict a week out, really. It was crazy. But it did mean that this year, a whole lot of relatively short-term deals came up for renewal, and there's been a lot of collective bargaining this year. This year, that bargaining has happened in an environment where CPI has been falling like a stone. And so at the beginning of the year, you were bargaining in an environment where CPI was still at 4%, and employees were thinking about the experience that they'd just lived through. And so they still had very large numbers in their minds. Employers were looking at what was happening in the economy and were looking forward, and they were taking an intelligent guess that something like this would happen. And so you had a whole lot of employers who were trying to get realistic deals done, but they were trying to explain that to employees whose lived experience was up here. And so that created quite a lot of tension at the beginning of the year because there was just such a mismatch between the real world that employees had been living in and employers' rational expectations about where pay movements in future years should be. As we walked through the year, it became more and more and more obvious that deals at around 2%, like they used to be back in the old days, were actually sensible and rational. And so more recently, it's become slightly easier to cut a deal at a semi-sensible rate. I think the other thing that's happened this year is that quite a few, both unions and employers, are simply exhausted by the processes that we've all been through over the last 4 years. And there's been quite a willingness to cut a longer term deal because on both sides of the table, just nobody has the energy for it anymore. On the union side, they are struggling for resource, they're struggling to attract talent, and they simply can't afford to be doing this every single year, and so they can't afford to do 1 year deals. And on the employer side, there are a tremendous number of employers who have been deeply cutting costs over the last 2 or 3 years, and it means those few of you who remain are desperately overworked. You have far more pressure on you than ever before. And the idea of doing a 1 year deal and then being back and bargaining again next year is just horrifying. And so quite a few employers have been willing to sort of bite the bullet and do a 2 or 3 year deal with the out years at CPI or 3%, whichever is greater, knowing that that's probably slightly too generous, but nonetheless doing the trade-off that it's better to pay 1% more or 2% more and get a deal done rather than being dragged into bargaining year after year after year. So that's kind of been the big feature of the year. Just a couple of other observations. First of all, as I just said, the unions continue to really struggle to attract talent and to attract genuine leaders. That is a real problem if you're trying to bargain, because you desperately need somebody to lead the workforce and to actually be able to kind of do a deal with and make it stick. I think the other thing that's happening on the union side of the table is that they watched the election last year with absolute horror and dismay, and they are disillusioned and frustrated and disappointed and overworked and underpaid like everybody else. And it just has meant that there really hasn't been the same fight in the union movement over the last 12 months that there was in the 3 or 4 or 5 years before that. So I think I am seeing more longer term documents than over the last few years. The one thing I have really noticed this year is that now that fair pay agreements have evaporated and they never amounted to anything at all, a number of unions are putting a lot more effort into fighting about passing on issues and about what happens to non-union staff and whether pay increases should be passed through to non-union staff. So that's been kind of interesting to watch. The legislation still doesn't work very well, and so they still haven't actually been able to achieve anything practical. They're just wasting a lot more time arguing about it than they have over the past kind of 5 or 6 years. And then I want to finish just with one favourite story of mine, which is, as you all know, when the national government or the coalition government came in, the first thing they did was repeal the fair pay agreements and all of the framework that went around it. Fascinatingly, Unite Union filed a set of proceedings in the Employment Relations Authority the day before the legislation was repealed, claiming that they should be entitled to a fair pay agreement for the hospitality sector. They then pursued that claim and alleged that because the law at the time they filed their claim allowed for fair pay agreements, then the authority had to award them a fair pay agreement because as a general rule, any court case should be judged by the law that applies at the time the court case is filed. So they pursued their claim. We had a hearing in the authority with a big argument. Well, I don't know, God knows how many employers in the hospitality FPA agreement. Eventually, the authority decided, blindingly obviously, that there was no way you could have a fair pay agreement once all of the framework and all of the mechanisms and all of the superstructure that was necessary to support it had disappeared. And so the authority said, look, even though we have to judge cases by the law applicable at the time, it's simply madness to pretend that there can be one sole surviving fair pay agreement, and so the case got thrown out. All very entertaining and an amusing waste of time, bearing in mind how short of staff and resources all the unions are. And it was surprising that they kind of picked that as a case worth pursuing. Anyway, that is collective bargaining for the year, and I hand over to Simon to talk about immigration.
Thank you, Andrew. We've got a lot of changes in immigration over the last 12 months, and we're limited to 10 minutes, so this is going to be a fairly rapid canter through all the changes. So I'll start with the changes to the visa settings, and in April this year, the government made some changes to the accredited employer work visa scheme, including new minimum skills requirements, a new English language requirement, and shorter visa length and stays for certain roles. In terms of the minimum skill requirements, applicants for new accredited employer work visas need to show evidence of their work experience or qualifications. And this is in addition to any skills or qualifications that the employer has identified are necessary for the job. So the applicants actually have to provide evidence, and the guidance is that that doesn't include documents they write themselves.
About ChatGPT.
Yeah, absolutely. So, it's obviously designed, I think, to capture CVs and to indicate that some further evidence is required, and there is an obligation on employers to actually check that they meet skill requirements before they offer the job. In terms of the English language requirement, so this is essentially limited to roles that are assessed as level 4 or level 5 under the ANSCO code, so the lower skilled roles generally. So applicants will need to show that they speak and understand English, but that requirement doesn't apply to the applicant's partners or children. Again, in terms of level 4 or level 5 ANSCO roles, jobs that pay at or above the accredited employer work visa wage rate are limited to a maximum visa length of 2 years, although there is the ability to apply for one further year with an additional check. with an additional job check. So what that actually means overall is the total visa length for those applicants, or sorry, the total time applicants in level 4 or 5 roles can stay in New Zealand has been reduced to 3 years. So that's from 5 years previously. Green list roles are more affected. In terms of migrant exploitation protection work visas, so on the 31st of October this year, the government removed the right to apply, or the ability to apply for a second MEPV. However, migrants who've made a credible report of exploitation will still be able to be granted an MEPV for up to 6 months or until the expiry of their current visa, and that's to enable them to leave the exploitative situation and to look for alternative work in New Zealand. Some helpful clarifications being provided that redundancy is not migrant exploitation. It also doesn't apply, interestingly, I think, to companies that have gone into liquidation. And basically, I think it's understandable, but obviously we're aware that some companies kind of liquidate to avoid potential liabilities. Third point, green list. So in March or April this year, 17 new roles were added to the green list. So our friends from Air New Zealand will know that that includes aviation engineer, aircraft maintenance engineers, also includes ICT database and system administrators. There have also been increases to visa charges, and I think this is perhaps more significant for applicants. So visa charges are made up, as you're probably aware of, visa fees and levies. According to the new government, the new visa charges have been set at an appropriate level to recover the costs of processing the visa and reflect the benefits received by people using immigration services. What it means in real terms is that if you're applying for a skilled migrant visa, the cost has gone up from 4,290 to 6,450. It's a fairly chunky increase. For our clients in the travel, tourism and horticultural sectors, there have been some improvements announced for seasonal workers. So in August this year, the government announced a new subcategory of the specific purpose work visa to provide relief, short-term relief for employers in industries with upcoming seasonal peaks. So this category is available to employers who are hiring migrants for roles that meet the definition of seasonal activity. It's an interim, time-limited, streamlined pathway into immigration. The cap on the number of recognised seasonal workers as well has been increased, so that's gone up to 20,750. And that's an increase of 1,250 from last year. We've also seen new migrant worker protections. So the first one's quite interesting in terms of school leaver rights. So since October this year, migrant high school leavers who are awaiting the outcome of a family residence application can apply to vary their visitor visa to give them access to part-time work rights. So that would allow them to work for 20 hours a week between February and November and 40 hours a week between December and January. Second point, new requirements and penalties for migrant employers. So the Worker Protection Act came into force in January this year. It introduced a suite of changes to the Immigration Act, to the Employment Relations Act and to the Companies Act. Key changes under the Immigration Act are that it requires employers to provide employment documents within 10 days of a request from an immigration officer. It also introduces 3 new very low-level immigration offences. So the first of those is employing workers who are not entitled to work in New Zealand. Second is employing a person in a way that is inconsistent with the individual's work visa conditions. And the third, linked to the earlier point, is failing to provide documents requested by an immigration officer. Another key change in the Immigration Act is a naming and shaming right. So the Chief Exec of MB has the authority to publish the names of employers who violate the Immigration Act. So to support the changes in the Worker Protection Act and to deter employers from exploiting individuals, the government launched a new immigration employment infringement scheme in April this year. Scheme allows MB Immigration to issue infringement notices to both accredited and non-accredited employers who commit any of those low-level offences that I just referred to. Infringement penalties include a minimum fine of $1,000 for individuals or $3,000 minimum fine for a corporate. It can also result in loss of accredited status or recognised seasonal employer status. Employers can also be stood down, so you can be put down on the stand-down list, which prevents you from supporting further work visas, although you are able to still employ people who have an open work visa, so it's not linked to employment. I think the stand-down period is generally 6 months for the first offence, 6 months for subsequent, a maximum of 12 months, and essentially you have to apply to the court to challenge and stand-down list. More serious immigration breaches can result in criminal charges. So that's it in terms of immigration. I will hand over to Scott, who's going to talk about restructuring and redundancy issues.
Great. Thank you, Simon. So a romp through restructuring and redundancy. As Hannah was saying earlier, obviously we've had a lot of news articles, reports, and obviously we've noticed at KPC that we're giving more advice about restructures, redundancies. Really, I think that's because there's obviously been a lot of financial uncertainty. There has been a kind of negative outlook, and there's been a quite significant reduction in government spending, which has trickled out into other areas of the economy. So if we're thinking about the basics of employer obligations, then these are them. A genuine business reason. So your proposal has to be based on something that's explicable, clear, and makes sense, and can be backed up by some evidence, which is the relevant information point. If there's a new structure, you need to explain what it is. There needs to be some facts and figures justifying the change, and also make sure those facts and figures are accurate. And if you're not sure they're accurate, you best leave it out and go on to something else. Consultation, you need to consult. Obviously, you guys all know that. How long? People ask me how long. Well, a couple of weeks. Fingers crossed. Might get you there, but you've got to accept there might be a longer process than that. And obviously, some employers who are here today know that the consultation process is much longer than that. Obviously, you need an open mind, and that means don't predetermine it. And that means if you're thinking about a restructure, be careful what you write down. You might want to consult us. We can privilege some of those conversations. But remembering that employees who are trying to contest this process can make a Privacy Act request. And if they find out that John Smith has been targeted because of something he did at the Christmas party, there might be a problem with that redundancy. And good faith, be open, listen, and have evidence that you're listening. It's fine to say later, oh, of course we listened. It's good to have some contemporaneous evidence that we listened, we thought about it, and we responded. There have been a couple of recent cases, probably you know about the TVNZ case from the media, and obviously TVNZ is a state broadcaster. It broadcasts free-to-air TV, therefore it's losing money, and the taxpayers paying for that. And so they thought, well, let's do a restructure and save some money. What they forgot to do was to read their employment agreement. It's a collective agreement in their case. And they began a restructure process, and they had a genuine reason. We're losing money. And they wanted to consult, and they hadn't predetermined the outcome and all those things. And yet the union was still pretty unhappy, and the union filed court proceedings about the restructure. And the reason they did that was because in the collective agreement that applied to TVNZ employees, there was essentially a pre-consultation requirement. So before you launched your restructure, you had to meet with the unions, meet with employees, try to come up with some joint solution that would solve everyone's problems. And only after you failed, tried really hard, but you failed, would you go to the next step of proposing a restructure where people lost their jobs. TVNZ didn't really bother with step one, and they got caught out. And the union went to court and won in the authority and in the court. And the court said, sorry, you haven't complied with the collective agreement, start again. So they had to go back to square one, start the whole process again and consult again. Quite how genuine that could all be, given they kind of had made a decision and they kind of, what's up there? And the union had it's not keen on reduction. Wasn't interested in my presentation. Given that it had gone through this, and of course everyone at fair go had been let go, like there was no more fair go. So what were they supposed to do about consulting about fair go? But sure, they went back and they consulted again. PSA and Secretary of Education is really similar. It's kind of the same thing, a pre-consultation requirement. And so the point here is, if you're, no matter whether you're a big employer or a small employer, an employer with a collective agreement or not, look at what your employment agreement says about redundancy and look at what your policies say about redundancy, because any employer has to comply with its own employment agreement and its own policy. And you might be surprised, particularly if you've got a lot of older employment agreements hanging around, what they say about redundancy and the process you have to follow. You don't follow it, you're in trouble. The other thing to talk about are a couple of issues that come up or have come up recently for us when we're talking about redundancies. One is selection criteria. That's obviously where you're moving. You've got 5 roles, you're moving to 3 roles. You need to find out who the 2 are who are unfortunately going to lose their jobs. Selection criteria are tough. They're difficult to work out and they require quite a lot of thought. So they really have to be worked out at the beginning of the process because you need to consult about them. You can't leave it till the end to work out who exactly those 2 are that are going to be made redundant. So you've got to be careful about developing them and you've got to be careful about applying them. So even if you go through all the steps, you consult about the process, you consult about the criteria, you go ahead with the restructure, you apply the criteria. Right at the end, you've got to be careful that your application of the criteria is transparent and fair, because if you can go through all the process, if you get the very last bit wrong, you could have a grievance with the client that a fair process wasn't achieved. And the final point is about redeployment. I think Hannah mentioned a couple of court decisions recently, which are very much focused on redeployment. That's where the court is focusing at the moment. It's saying, you've got to make really fulsome efforts to try and find this person another job. And obviously in the current environment, that's something that's going to hit home. There's going to be claims of people saying, I could have taken that job over there, kept my job. I wanted that job, but you didn't give it to me. So very much active engagement with redeployment. And there's a recent case called Stellar Investments where the company called Stellar was a New Zealand branch of a multinational corporation with offices all around the world. And the employee in New Zealand interacted with all those people overseas. And so his team was based in Singapore and Canada and Australia and wherever. And they made part of that team redundant, including him, as part of a worldwide process where they reduced costs and reduced staff. And the court said, well, in that situation, it was incumbent on the New Zealand employer to try and think about what other roles this person could go into overseas and try and get an opportunity for him to go into those overseas roles. That was what a fair and reasonable employer would do. So if you're in one of those situations, you do get that, a reasonable amount where it's part of a international team or this international group of companies all operating together, just focusing on New Zealand and saying, oh, there's no role in New Zealand, really isn't enough. You've got to think about whether there might be a role overseas. So I'll hand over to, I think, Anthony and Ekra, who are going to talk to you about some other recent cases.
All right. So it's been a very good year for interesting cases. And Ikra and I have picked 4 particularly interesting ones that we're going to talk to. I'll talk to the first 2, and I'll hand over to Ikra the second 2. So the first one that I want to talk about is MW and Spiga. So the facts of this case were that we had an employee who we only know by the name MW, who worked at Spiga Limited, which is a wonderful little restaurant, Italian restaurant out in Europe. MW had worked at Spiga for about 3 months when an employment dispute arose. The parties went to mediation. At mediation, it was agreed that MW would leave employment under the terms of the settlement agreement. As is quite standard, that settlement agreement included terms around confidentiality. The settlement agreement was certified by a mediator, so all pretty standard so far. But then after mediation, Spiga breached the confidentiality clauses. MW found out about that breach and took Spiga to the Employment Relations Authority seeking penalties for the breach and orders requiring Spiga to comply with confidentiality provisions going forward. Now, MW knew that in bringing this case to the authority would make a determination that was going to be public record. And so MW knew that if that went down the normal route, it would sort of defeat the purpose when a determination showed up that said its name and the details of the settlement. So MW sought non-publication orders. The authority determined in MW's favour, saying there had been breaches and that MW was entitled to the orders sought. But when it came to non-publication, the authority decided that it would only make non-publication orders to preserve the confidentiality of the terms of settlement, but not MW's name. MW was quite upset with that result and challenged the authority's determination on that non-publication point to the court. Spiga Limited didn't oppose the challenge. It's really no interest to them. And ordinarily, when you have an unopposed challenge, it's quite easy for the court to decide. But this time was a little bit different. Now, the court saw this as an opportunity to revisit the law on non-publication orders to see where the principles that have been in place since the days of hard copy registries and libraries was fit for purpose in 2024, when we have the internet, when we have generative AI, when we have the ability to search the names of any parties with a few keystrokes. And attention was in particular given to this idea of blacklisting, this idea that employers go around and search up names of job applicants and create lists of people who have been involved in employment litigation they aren't going to hire. So, seen as a big ticket item, a full bench of 4 employment court judges was convened. And because, as I said, Spiga didn't want any part in this decision, the court invited basically anybody who felt interested to provide submissions as third-party interveners. And when I say basically anyone who's interested, I mean Council of Trade Unions, the New Zealand Law Society, Law Association, the Employment Law Institute of New Zealand, the Privacy Commission, the EMA, HRINZ, Stuff Media, NZME, Radio New Zealand, Te Hunga Roa Māori o Aotearoa, and Business New Zealand, represented by Peter Kiley and yours truly. So it was less of a courtroom and more like a small stadium. And with the benefit of all of that participation, the court considered the current state of the law on non-publication orders. And what we had was a split decision. 3 of the 4 judges arrived at the majority, which upheld the status quo. In particular, the starting point when assessing non-publication is the principle of open justice. It's a fundamental principle. To depart from that starting point, there need to be sound reasons which are necessary to serve the ends of justice. A departure is going to require a reason to believe specific adverse consequences could be expected to occur if information is published, as well as a weighing exercise of factors on a case-by-case basis. Those factors include the circumstances, the interests of the parties, and, where appropriate, tikanga. The court did not define tikanga or its principles, but said that caution must be applied, and the role that tikanga may play will need to be determined on a case-by-case basis. Interestingly, the majority also found there was no clear evidence of blacklisting by employers in New Zealand, but said that that may change depending on technological developments. So the majority applied the standard approach, reversed the authority decision, granted the non-publication orders protecting the MW's real name. This case received quite a bit of attention in the media because it touched on some fundamental questions around why we expect parties in employment disputes to be named publicly in decisions that are available on the record, and whether that's fair, whether that's right. I mean, one of the tools that's in the toolbox when litigation is threatened or is underway is that the majority of the time that decision is going to be public record and publicly available. That means that an employer who has done wrong can be named and shamed, but it also means that vexatious individual litigants can be seen for what they are. And also we expect the courts as public bodies to have decisions that are available and searchable, unless there's good reason why there shouldn't be. So this decision has settled that question, at least for now. The second case I'd like to talk about was Ford and Henry Brown and Co. So the facts of this case are Mr. Ford applied for a job at Henry Brown, which was a family-owned construction company. The interview process was very relaxed. Mr. Ford was asked to provide some referees, which he did. The company spoke with one of those referees, who was one of Mr. Ford's colleagues at his previous job. The company asked that referee why Mr. Ford had left, and the referee said, well, there were issues with the general manager. For whatever reason, I don't quite know why the company didn't actually pull on that thread to find out what those issues were. The company just said, oh, okay, fair enough, well, we'll offer him the job. And he accepted. He signed an employment agreement which contained quite a standard clause that said the representations that Mr. Ford had made before starting employment were true and correct, and that he had disclosed everything that may have been material to the decision to employ him. In the beginning, things went well, but pretty soon afterwards, issues arose regarding his behaviour and how he was interacting with staff and managers and subcontractors and clients. And Mr. Ford then raised personal grievance claims, alleging health and safety breaches and bullying and harassment. It was at this point that the company then spoke with Mr. Ford's previous employer, who had then told them that he'd been fired from the previous job and that the company's better off without him. So then the company then counterclaimed that Mr. Ford had breached his employment agreement, which had that clause I spoke about, that misrepresentations clause, because allegedly he hadn't advised that he'd been dismissed from his previous role, and this was material to the decision to employ him. So it went before the authority dismissed all claims from both sides. It then went to the employment court, and the court really drilled down into this misrepresentation point. The court said that a misrepresentation suggests that something untrue was said, but here Mr. Ford hadn't said anything. The court also concluded that the employment agreement did not require Mr. Ford to proactively disclose that he had been dismissed from his previous employment if he hadn't been asked. So on that basis, the court found that he had been unjustifiably dismissed, ordered the company to pay him 9 weeks lost wages and $9,000 compensation and costs. So this case is a sort of classic cautionary tale about bad hires. Things would have been quite different. The company had delved a little bit deeper and had asked that question at the interview stage, but the company couldn't rely on the misrepresentation clause coming to save it when its true colours came out. Anyway, so I'm now going to hand over to Hector for 2 other very interesting cases.
Exactly. The first case that I'll be discussing is the Susie Wiles case, just because I thought everyone will know who Susie is. So this is an interesting case which discusses the health and safety obligations of an employer in a relatively unique situation at the time. So just quickly on the background, we all remember that during the COVID-19 pandemic, Professor Susie Wiles was a prominent figure who provided expert advice and commentary on the pandemic for mainstream media platforms. However, unfortunately, Professor Wiles was subjected to severe harassment on essentially all platforms, so email, social media. She was even in person. Her private contact information, so her mobile phone number, her house address, and someone also posted photos of her house online. So very concerning behaviour. And naturally, Professor Wiles reported these incidents to the university in 2020, and then continued to update the university as the harassment increased. In response to these safety concerns, the university consulted with Professor Wiles and other academics who had complained of the same thing, and asked them what steps they wished the university would take in order to deal with these concerns. And later on in the judgment, we see that Professor Wiles actually criticises this approach and says that I'm not an expert in security matters, so it was up to the university to figure out what it needed to do to address these concerns. And we see that the court actually agreed with this observation. And so as part of dealing with these health and safety concerns, the university informed Professor Wiles that providing commentary on COVID-19 was not a part of her role at the university. And so she should limit these activities to decrease this health and safety risk. So eventually and naturally, Professor Wiles raised a personal grievance against the university for unjustified disadvantage, breach of good faith, and for breaching its health and safety obligations towards her. And so the university in response argued that Professor Wiles was not required to provide public commentary as part of her employment with the university, and therefore this was not work for which it owed health and safety duties towards Professor Wiles. But however, we see that by the time this case reached the employment court, the university agreed that her appearances did constitute work. In terms of the findings of the employment court, the court held that the university did breach its health and safety obligations by failing to provide adequate protection and support. And the court said that whilst there was a health and safety plan in place, and they did take a number of steps to ensure safety, including a security audit, those actions did not happen quick enough, nor were they sufficient. And it also said that the existing health and safety plan had to evolve to deal and respond with the circumstances as they arose. And so in Judge Holden's words, he said that the university's response was reactive and it wasn't expansive enough. The court also considered that harassment of academics was not a new phenomenon, especially against women. And so the onus was really on the university to figure out what it needed to do to protect its staff. And it was on the university to proactively manage that risk. And the court also criticised the university, telling Professor Wiles that she should stop providing commentary so that the harassment would decrease. And it was specifically noted that this was a significant failure in the university's response to her concerns. It also agreed with Professor Wiles, as I mentioned earlier, that it was not for her to provide solutions to these health and safety concerns, and she was entitled to have the university figure that out. There are some important lessons from this case, including that employers should be mindful of employees' work-related activities outside of the work premises, and proactively being the key word, consider what it can do to manage these concerns and risks. And as Hannah mentioned earlier, this case also highlights that employers do have a duty to protect the employee from psychosocial risks such as harassment, even when they are not directly caused by the employer. And ultimately, the key takeaway from the case was that the onus is on the employer to figure out what it needs to do to deal with these health and safety concerns. And whilst consultation is obviously advisable, the employer needs to take the lead and not leave most of the thinking for the employee. Second case that I will be talking about in the last case is Peters and Marlborough Free Kindergarten Association. It's an authority decision, but I thought the subject matter was quite interesting because it considers a situation of what happens if you reach settlement, you've done all of this hard work, both parties sign the agreement, and then the employee refuses to enable the mediator from signing off on the agreement. And so this was the case in Peters and Marlborough. The employee worked for the association, and during her employment, she was investigated for misconduct. And soon after the investigation process commenced, a union advocate represented her, went to the investigation meetings, and during those investigation meetings, the investigator let the union advocate know of their initial views on the complaints. This prompted the union advocate to invite the employer to make an offer to settle. And they said that the employee would be willing to resign if the investigation ended and a reasonable settlement was agreed. The employer obliged, an exit package was agreed, both parties signed the settlement agreement, the union advocate lodged it with MBIE, and then no word, there was a delay. So the employer follows up on this, what's going on, and they get told that the employee has changed her mind and she's not enabling the mediator from signing the settlement agreement. Following this, the employee hires a different representative and lodges files a statement of problem, listing out all of the issues and complaints she has about her employer during her relationship. And very sensibly, I think, the employer argued that the employee was prevented from bringing these claims because they had already signed a settlement agreement. In terms of the determination, the authority sensibly agreed with the employer and held that the employee was prevented, or in their own words, stopped from bringing her claims because she created a belief of expectation by signing the settlement agreement that all matters had been settled. Interestingly, the employee tried a variety of arguments to convince the authority of why the agreement should not be upheld. And one of them was that the agreement could not be enforceable because the mediator didn't sign it and because she did not get the chance to talk to a mediator before signing the settlement document. So the authority considered this and said that while Section 149 of the Employment Relations Act provides a statutory mechanism for resolving employment problems, and there is a process where a mediator signs off on the settlement agreement, this does not mean that parties cannot also be bound in the employment context by agreements that they reach that have not been through this process. And they cited employment court precedent and considered that actually the effect of a Section 149 settlement is that it provides a statutory mechanism for compliance should a party fail to uphold their end of the deal. So again, confirming that an agreement signed off by both parties is just as valid as an agreement signed off by a mediator. And so the authority rejected the argument that the settlement agreement was not enforceable, and so she couldn't bring her claims to the authority. Just some key takeaways. An important reassurance that once both parties have signed a settlement agreement, it is full and final, and parties are stopped from acting as if it was unenforceable. And I found a useful tip for some of us that might be drafting settlement agreements. In this particular case, the employer put in a clause which said that irrespective of whether the process under Section 149 had been completed, the agreement is binding and enforceable once both parties have signed the document. So I thought that was a really useful tip for all of us to include, just to be very clear about the intent that this agreement is full and final once both parties have signed. That is it from Anthony and I, and now I will pass on to Dana, who will talk about all things Holiday Acts.
Okay, so Holidays Act reform, very exciting. Our current Holidays Act 2003, well, as I'm sure everyone knows, it has its problems. It is complicated, it can be confusing, and in places it's just not very clear. That confusion and complication is especially so the case for employees who, for whatever reason, don't work a traditional work pattern. So that could be in terms of hours, where employees are working different hours depending on what day of the week it is, or what roster they're in, or what week it is. And it's also the case for employees whose remuneration is changing over time, whether that's because they're being paid a bonus from time to time, they get different rates of pay for different duties, they work on a commission basis, or whatever it may be, that means their pay changes and is not predictable. As a consequence, what we've seen is that the Holidays Act is hard, and sometimes employers, they get it wrong. And that means there have been incorrect payments and sometimes underpayments. And I'm sure everyone has seen in the news on a fairly regular basis, another Holidays Act remediation project has been announced on an incredibly large scale. But thankfully, the government has a plan, or at least concepts of a plan, to fix it. And I should say that it's not just the current coalition government that's wanted to fix the Holidays Act. This has been on the political agenda for quite some time, maybe at least 6 or 7 years now. But the current government is appearing to make some real progress. Where we're at right now is that an exposure draft of the employment leave bill has been circulated out for targeted consultation to a group of about 100 or so parties who are interested, particularly interested in the bill. The indication from the government is that that new bill, which would be a bill to completely replace our current act, will be introduced to Parliament before Christmas. However, and shockingly how quickly time goes, but there's only 9 sitting days left on the parliamentary calendar. And so I think it's entirely possible we might not see the bill in the public until next year. So moving on to what might we see when the bill's released to the public? MB has helpfully proactively released cabinet papers and other documents which set out in quite a lot of detail the changes the government's looking at, and also the alternatives to those changes at the same time. In terms of annual leave, what we know is that we're likely to move to an accrual system, which would be a weeks-based accrual system. As I'm sure most of you know, currently annual leave is like Monopoly, where you go around the board 12 months of continuous employment and you collect your 4 weeks of annual leave at the time you pass go. Instead, it'll be more like a piggy bank, where for every week that you sit at your desk, you bank an amount of annual leave. It's an easy to remember amount. It's the rate of 0.0678 weeks of annual leave per week of employment. That's what has been indicated so far. And then in terms of what that would be worth at the time annual leave was paid out, so say on termination, for example, the proposal is that annual leave would be paid out based on the greatest of 3 separate calculations. There's also an expected change in terms of what will happen to annual leave if you're one of those people who's just returned from parental leave. You might not be aware, but currently under the Holidays Act, if you are on a period of parental leave and you return to work and then immediately would like to take some annual leave, your annual leave under the Holidays Act is likely to be paid out at a lower rate because it's based on your previous 12 months when you're on parental leave and not earning as much. So there's a proposal to change how that works, which I think makes sense. I'm sure anyone who's actually cared for a newborn will say that parental leave is nothing like an annual holiday. And finally, and perhaps of interest, we do know that there's a proposal for a new expanded definition of gross earnings. At the moment, we have our current Holidays Act and the Court of Appeal's guidance in the Metro Glass case to help us decide whether or not we should include that senior executive's quite hefty bonus in some cases in the calculation of holiday pay. However, if we have a new and importantly expanded definitions of gross earnings, that position could change, and we might also lose some of the guidance from the Court of Appeal, depending on how the new definition is framed up. Moving along to FBAPS leave. So that's family violence, bereavement, alternative holidays, public holidays, and sick leave. The proposal is to simplify the calculation of that leave. But I've had a look at the documents and I'm not sure it's that much easier, but we will wait and see. There's also proposals to change when you might be eligible to take that leave. So the government's considering whether employees should be able to take family leave, bereavement leave, and sick leave from day one of employment instead of after 6 months of continuous employment. And finally, on sick leave, there's also an indication that the government is considering a pro rata approach, whereby full-time employees would still be entitled to the full 10 days sick leave. Part-time employees would be entitled to a proportionate amount of that 10 days, but that there would be a floor of 5 days sick leave for everyone, no matter how little or not you work. So that's kind of the key proposals in terms of annual leave and FBAS leave. There are other proposals being considered, but I just wanted to highlight those in particular as I think they're probably the most interesting. Moving on to what problems employers might face and some things to think about. Firstly, it just goes without saying this would be a completely new act. It's obviously been designed based on the problems of the current act, so I expect it will have lots of the same bones to it. But it's a new act and there will be new uncertainties and things that frankly no one will see coming until the issues are being litigated about. We also understand this new bill and new act is being designed with payroll providers at front of mind, which makes perfect sense as payroll providers have the fun task of reading legislation and coding it into software that works perfectly every single time. But what that means for employers who have the obligation to pay correctly is that you're likely to be increasingly reliant on your payroll provider to get this right and to get the new act right. And then for smaller scale employers, there will be the question of whether it's practicable and whether it's possible to achieve compliance without the assistance of a fairly comprehensive payroll provider. There's also likely to be some challenges in terms of the transition to a new act. A good example is what will happen to your current annual leave balances. How will those be shifted over to the new act? What will they be worth? Is there an issue if they're worth slightly less under the new greatest of three calculations? What would that mean? What would it mean in terms of that set of leave, which isn't really Holidays Act leave, but might have been an extra week entitlement that your employer gave to you on a discretionary basis? How would that sort of leave transition over, or would it transition over? All of those headaches are likely to arise, and we'll have some clarity once we see the bill. But employers, of course, at the moment have the option of thinking about whether they might be encouraging or even requiring employees to take some annual leave, so to have those leave balances shrink and therefore shrink the size of the potential problem in terms of a transition to a new Holidays Act. And finally, it's entirely possible we might see further delays on this project. That was the pattern in the past, although I am hopeful that we will hopefully see a bill introduced early next year and then pass through Parliament. And then we might have something like, at a guess, maybe an 18-month lead in before compliance is expected. But look, who's to say? We will find out either before Christmas or perhaps more likely next year. And I will now pass over to Jaya, who's going to talk to you about a whole bunch of things, I think.
Thanks, Dana. We've all been sitting for a little while. If anyone wants to have a little shuffle, or they're welcome to. It's been a very interesting night so far. I'm going to talk to you today about environmental, social and governance issues that have occurred of late, and particularly issues that we're seeing in the media, some of which have been touched on already this evening. Some of these issues obviously impact the way that we work and the way that our people work. So the purpose of my talk today is to identify areas in which your organisation can be proactive in engaging in what these issues are, proactive in managing, thinking about things like policies, like trainings, to try and optimise how these issues are impacting your workforce. As Hannah touched on and Anthony also touched on earlier, generative AI is fundamentally changing the way many of us work and will work in the future. It can create content like letters, pictures, marketing material. It can even create the next email in a chain, taking on the likeness and the way that the email was previously written. But AI doesn't always get it right. There are safety issues, there are biases, there are mistakes, and there are even what is called hallucinations, where the generative AI essentially makes up an answer because it doesn't already have one. The end result is that any AI output needs to still be screened by a human. And these tools aren't always capable of understanding the emotional or the business context, or even understanding where they're getting it wrong. We have seen cases, not in New Zealand, but in the UK and the US, where generative AI has produced case citations that are completely made up. Luckily, we're not seeing that here, but that is something that we may yet see. So organisations such as yours need to consider how you want to interact with generative AI. And I know that maybe there may be a generational shift between older employees and younger employees that are coming through. But I think at this point, it would be unwise to consider that generative AI is not already being used in your businesses. And I think it could create legal and reputational risks. So engaging with generative AI, understanding what it is, how it works, and creating policies and guardrails is going to be really important. I guess what I'm getting at is it's being used whether you like it or not, and we'll well move past the ability to ban it or to require employers to not use it. If you haven't already used a tool such as ChatGPT or WALL-E or Copilot, which is the Microsoft tool, or Gemini or Vertex, I really encourage you to do it. It's going to be very difficult for your organisation to understand how it's being used and why it's being used if you don't actually understand how the tools themselves work. Generative AI can create great efficiencies, like automating repetitive tasks. It can facilitate faster decision makings by analysing a lot of data within a short space of time, and it can increase productivity by using machine learning. So our top tips are: implement a policy with guardrails for use in the workplace. Understanding generative AI and its limitations. You really need to get yourself in the know. Protect privacy, private information, confidential information. Ensure accountability and accuracy. If your employees are using these tools, it needs to be correct, and they need to be accountable, and they need to be double checking it as a human that it is doing what it needs to be doing. Be aware of ethical issues. As I said, there are baked in biases in the generative AI tools. They're only as clever as the data that they were trained on. And as humans, we all have inherent biases, so those biases are baked into these tools. And to manage and disclose AI use. If your teams are using AI, they should be documenting it. They should be saving down the original output so that if they are adding any of their own intellectual property, if they're adding any of their own thought or judgment, that you're able to distinguish. So policy tips. Having a policy and guardrails and understanding how this technology works is really the minimum of what you need to be doing to manage this new generation of technology within your workplace. Employees need to be aware of what they can and can't do and what the consequences are if they don't do it right. Most employees may not know better and consider that they're actually just being savvy and using all the benefits that generative AI has to offer. So your policy should cover the guidelines for use, which employees it applies to, and it should expressly state that it applies to any third parties that you engage within your workplace, like consultants or contractors. It should cover the extent to which AI is allowed to be used, any restricted platforms, and any limits. So, for example, if confidential information is a problem, you may want to ensure that the generative AI tool that you're using is locked down to your particular workplace environment. Whether approval is required, whether there are particular tasks that are only approved to be used, and require your employees to confirm whether they're relying on AI, when and for what task. It's recommended that any outputs that they created, I mentioned this earlier, are documented, which is particularly relevant for copyright and the application of your own independent thought and judgment. AI outputs should always be reviewed for accuracy and shouldn't be the final process. It needs to be checked. You never know when an AI tool might be hallucinating and create something completely false or ridiculous. Data and privacy security is a really important issue. If you put personal information or confidential information into a public generative AI tool, that information is no longer confidential. It will be used in the training of the AI tool and may be used as an output for any future user. So that is really important that if your employees are using a tool, that they use it in a way that doesn't share personal information, confidential information, or intellectual property from your organisation. You also need to ensure that your organisation's commitment to diversity is not compromised during use, including for AI-supported processes. We've talked a lot today about redundancy and changes within an organisation. AI tools can be used for recruitment, for promotion, and for potential redundancy selection. And some of those inherent biases could actually impact the diversity of your business. It's also really important to set out the consequences for not adhering to the policy. If there is a breach, will it result in potential disciplinary action? Could that lead to dismissal? Once you've implemented it, it needs to be reviewed regularly. I know that most businesses have periodic reviews for particular policies, but this technology is changing so quickly, you may actually want to be reviewing more regularly than some of your more static policies. You may also want to consider training, ensuring that our AI is used in the most appropriate way and the most beneficial way for your company to get the best outcome. Now, Hannah touched on work from home and hybrid working that has fundamentally changed the way that we work. The combination of technology and flexible working has enabled connection 24/7, but it's come at a cost. The other thing that we've seen is workplace surveillance that really exploded during COVID-19 and the work from home years. The technology has developed significantly. We're no longer talking about simple CCTV or signing in and out monitoring. What is commonly used in many organisations at the moment is much more invasive. They monitor emails, log in, log off times, webcams, chats, searches online, and keystroke logging, which really monitors every stroke that the employee makes on a keyboard or use of their mouse. This constant surveillance is now a core feature of algorithmic management software, and it gathers data from laptops, from biometric scanners, smartphones, AI searches of social media and worker-driven vehicles. The thing that I think is most concerning and that you as employers should be aware of is that this technology doesn't switch off when your employees do. It doesn't switch off when they go home, doesn't switch off when they log off, which goes to my next point about kind of the reasonableness of some of this monitoring. So workplace surveillance laws in New Zealand have been slow in catching up with these technological advancements. It's lawful in New Zealand on the basis that the employer is complying with their privacy obligations, where the collection is not unlawful, unfair, or unreasonably intrusive. Now, if you are monitoring an employee's phone while they are not at work, the question that I would be asking myself is that intrusive? So you should be reviewing and monitoring workplace surveillance that you are undertaking and just making sure that you are compliant and that you're comfortable with the level of surveillance that is undertaken. It's a timely reminder to review policies, and not just your privacy policy. You might have a workplace surveillance policy and a workplace equipment and social media policy, and make sure that your employees are aware of what surveillance activities you actually are undertaking. You might also want to consider training on workplace surveillance, conducting privacy impact assessments on employee data, and testing your cybersecurity risk. And the news we have seen overseas and in New Zealand, pretty significant data breaches involving both customer data and also employee data. So our key tips are having a lawful purpose for collecting the personal information, making employees aware, updating and developing surveillance and privacy policies, ensuring any monitoring is fair and not unreasonably intrusive, ensuring any recordings or personal information are stored safely and securely and for no longer than necessary. So once that information is no longer relevant, once that employee is no longer your employee, you shouldn't be keeping that information any longer. And to only use or disclose the personal information for the purpose for which it was collected, which might mean that your policy needs to clearly address that you will use this information for disciplinary purposes, because if it doesn't, it may be a problem for you to use that information, CCTV or keystroke logging, within the course of a disciplinary investigation. So with the blurring of the lines the last few years between home and work, Australia has recently introduced the right to disconnect legislation that's designed to regulate and set limits for out-of-hours communication between employers and their employees. Rather than banning all forms of out-of-hours contact, the law focuses on creating reasonable boundaries to protect employees' personal time and reflects a growing recognition of the need to balance work and home life, particularly in an era where modern communication often blurs the lines. The key aspects of the legislation are that employees now have a right to refuse to monitor, read, or respond to their work-related communications outside work hours, provided that their refusal is not deemed unreasonable. Now, the reasonableness criteria includes the level of disruption for the employee's role and responsibilities. It might be more reasonable the more senior the employee is, their personal circumstances, and any legal requirements for contact. Many countries have similar regulations. There's quite a few actually. Countries like France, Belgium, Italy, Argentina, the Philippines, Mexico, Russia, Slovakia, Spain, the list goes on. Employer contact outside of work hours that is frequent, demanding, or disruptive may also be a psychosocial hazard and may pose a risk to mental and psychological well-being. And therefore, employers may have duties to minimise or eliminate this. In New Zealand, the Health and Safety at Work Act places an obligation on employers to protect workers' well-being and to take all reasonably practicable steps to eliminate or minimise these health and safety risks. So whilst we don't expressly have laws that regulate the right to disconnect, New Zealand employers do still have an obligation to consider the health and safety impacts of employees being connected to work outside of their ordinary working hours and to manage those risks. Regardless of whether we introduce any legislation addressing this, employers may wish to consider policies and guardrails around reasonable out-of-hours work for health and safety reasons and for work-life balance reasons. Some of the things that you might want to consider is continuously assessing the minimisation of health and safety risks associated with outside of work contact, ensuring employment agreements have a valid availability clause providing for reasonable compensation, ensuring that you have an appropriate employment agreements and policies in place. For example, you might want to have guidelines around after-hours work, including limiting after-hours emails, text messages, and phone calls. Or some employees have that few words in the email signature saying, "I'm sending this late, but you don't have to respond to the next working day," which goes to fostering a workplace culture which sets healthy boundaries, including respecting employees' personal time, reviewing employee working hours and work-related contact in line with managing health and safety risks, and ensuring that your employees are regularly taking annual leave to rest, recharge, pursue their interests, and time with friends and family. That gives us a quick run through of the right to disconnect, and I will hand over to Peter.
Good afternoon, everybody. The relevance of independent contractors or employees, I find, comes up for three reasons. Parties have entered into what they think is an independent contractor arrangement, and time passes and the employer or the company says, "I don't want to renew it," or "I'm renewing it early." And then the other party says, "Well, no, I don't want it to end. It's all very nice, thank you. Actually, I'm an employee, I'm not a contractor." That's the first scenario. The second scenario I find is that the independent contractor says, "Well, look, now that I've done the calculations and everybody else has had 4 weeks holiday and public holidays and alternative days. And even if I look out my hourly rate in terms of what I'm working, I haven't been paid the minimum wage or got the extra entitlements. And again, I'm an employee, not an independent contractor. And the third scenario, rare, but I get it about once a year, is when the independent contractor has gone to the company and said to the company, look, I'm in charge of my own tax, I'll send you an invoice, but the independent contractor doesn't pay the tax to the Inland Revenue, and the revenue comes to the company and says, well, actually, the tax hasn't been paid. The primary obligation is on the employer, and we, the Inland Revenue, as we look at the arrangement, we deem you to be an employer-employee relationship. So those are the three scenarios, which is, of course, is a bit of a nightmare. The starting point is Section 6 of the Employment Relations Act, which is up on the screen, but I'm going to use colloquial language. It doesn't matter what the contract says, it doesn't matter what the paperwork says, the Employment Relations Authority or the Employment Court can look at all of the facts and determine what the real nature is. And we find with Australian clients, or in particular, or SMEs or Americans, they say, but why is this a problem? They've signed a contract, and we have to gently explain that statute trumps private agreement. It doesn't matter what the paperwork says, it's the real nature. And it all came to a head during Lord of the Rings and a model maker who, it was the scenario that I said, the arrangement was terminated. The model maker, Sir Peter Jackson, and we'd have said, we don't like the models that you're making, people aren't buying them, the agreement is terminated. I simplify it, but basically that. And the model maker said, well, hang on, you can't do that. I'm actually an employee. And it went all the way to the Supreme Court, and the court, in simple terms, said it's the real nature of the relationship, and we're going to look at all relevant matters. So that was one side of it. So what is a contractor? Well, the Act says that a contractor is everything else other than an employee. So it's a bit of a perverse argument, but that was that. It came to the fore recently with a case involving Uber drivers. And our firm, we appeared for Business New Zealand on the Court of Appeal as one of two interveners, the CTU on one side of Business New Zealand. So whilst we weren't second counsel for Uber, because we have to look at all businesses, it was a little bit of a mirror argument. And why the Uber case was so interesting, because Peter Cranny, the CTU union lawyer, who's a very clever guy, and companies like Air New Zealand and other companies here, they know Peter Cranny. And in the first case that Uber contested it, the plaintiffs were Uber drivers who worked for other companies, not just Uber, and the court found that because they could work for competitors, I think was the real reason, they were in fact genuinely independent contractors. But in the second case, the one that they did here, the first union very cleverly got 4 plaintiffs who only worked for Uber. So they didn't work for Wellington Combined, they didn't work for Zoomy, they only worked for Uber. And in the employment court hearing, there wasn't any evidence that they could have worked for other companies. And that's going to be important in terms of my next slide about the bill that will be introduced to Parliament. But unfortunately, as often happens in the court can often be a little bit activist, and it introduced a completely new criterion that doesn't appear, and said and looked and said, well, Uber drivers are vulnerable, and there's nothing in the Act that talks about that at all. The court had introduced a totally new factor. So when it went to the Court of Appeal, it found on the facts that for these 4 individual Uber drivers who only worked for Uber, who didn't work for Zoomy, who didn't work for Kiwi Cabs, who didn't work for Wellington Combined, for those 4 individuals, they effectively were employees. So the government has stepped in and indicated that it will introduce a new legislative test called a gateway test. The minister refers to achieving certainty and clarity. And it's going to be introduced into Parliament next year. I'm not going to read all 4 because of time. You can read that. But essentially, if there is a written agreement that doesn't prevent anyone from working for anyone else and doesn't require the person to be available and doesn't require the person to work a certain number of hours and doesn't say, if you don't turn up or don't accept this role, it will come to an end. So what people say has become a little bit of a political debate. If you look at those 4 bullet points, they all really don't, they have the feature of an Uber driver. So, but it's only a gateway test. If you meet those 4 points, you can't then go ahead and bring a personal grievance. But all that then happens is you go back into the normal test of the real nature. And the real nature is a number of tests. The court essentially stands back and says, 1, what have the parties have agreed? 2, can you work for a competitor? 3, are you really in business or on your own account? And who really controls the relationship? Is the one side of the party a boss and a person standing back? If you've got a uniform and the appearance of being integrated into the business, then you've got the features probably more of an employee than a contractor. So I've been listening to a number of the presentations tonight. I suppose this is the reason we all have jobs, is that employment law is a very fluid, changing nature of business and legal work. And that's a wonderful introduction for the next speaker, David, about what's to come in 2025.
All right. Speaking of Uber, you'll be pleased to know I'm the last cab off the rank. So those of you who I've seen looking at your watches or looking longingly over at the half-drunk bottle of wine, I intend to be quick. And I can be quick because the beauty of me getting the topic what's to come in 2025 is that half the speakers have already discussed or given some view on what's to come in 2025, which makes my job tonight a lot easier and hopefully a lot quicker for everyone. All right, what I intend to do is talk briefly about legislation and then we'll move on to some cases which may be arising next year. So thankfully, Dana talked very well about the Holidays Act amendment, so I don't have to. And Peter talked about the employee status test, which is the 4 parts of the gateway test, which looks like that's going to come into law sometime next year. So I get to talk a little bit about the minor pieces of legislation which are going to be introduced or may well be introduced as amendments into the Employment Relations Act over the next 12 months. The first topic is the employee remuneration disclosure amendment to the Act, which was recently drawn out as a bill. And this is quite a specific piece or amendment to the Act, which deals with the issue of pay secrecy. And what that is about is enabling employees to be able to talk about their pay with others without being subject to any adverse action. Not something I was particularly aware of as an issue, but may well be something that people confront who have their own businesses confront from time to time. The intention is to introduce a new personal grievance, which will make it a grievance, or which will give grounds for an employee to raise a grievance if they are disadvantaged by their employer as a result of the employer finding out they've shared with their colleagues what they are paid. The other relatively interesting, actually, amendment which is on the cards to be introduced concerns the termination of employment by agreement amendment. And what that is designed to provide for is the ability of an employer or an employee to have a discussion about ending an employment relationship where there is not yet a dispute or a personal grievance on the cards or raised, and for that discussion to be protected so that it can't be used against the employer in particular at a later date if the employer looks to engage with an employee about a potential exit from the organisation for whatever reason, face doesn't fit, pending restructure, which you want to try and avoid, or performance grounds, and consequently or subsequently have the employee raise that as part of a grievance against the employer. So like the lawyers here, and there are a few of you, we do from time to time have discussions with our clients about how to go about raising the sensitive issue of with an employee of, well, really you're not wanted around here anymore. And the fishhooks that arise with that. And if we're fortunate, we get contacted by our clients before they've had the discussion. If the client's unfortunate, they contact us after they've had the discussion. But invariably, it is a tricky issue to address, and this law looks to make it a little bit easier for the employer to have those discussions. So it'll be interesting to see how that could actually work in practice, given other obligations of good faith and the like. Other pending changes which didn't make the list, the amendments to the Crimes Act, theft as an employer looks like it's gone through its second reading and could become law over the next few months, and that will make it a criminal offence for an employer to not pay an employee wages that are due and owing, or withhold wages from an employee. So that could be an interesting, tricky little issue, and there'll be other arguments around their colour of right and the like. I'm sure that will come up. That's a nice criminal legal term I learnt at law school and have used since, but I thought I'd pluck that one out for you. But it's an interesting little issue which we'll tell you more about if it becomes law. And there's Privacy Act changes as well regarding collection by an organisation, for example, an employer, of information concerning an individual, for example, an employee, from a third party. And that's proposed to be introduced as one of the called the privacy information principles that they have at the Privacy Act. I'm not sure of the status of that, but it's gained some interesting discussion around the traps over the past few months. All right, leaning into pending court hearings. So I've just plucked a few out of the Court of Appeal that may interest you. There's lots of other ones in the Court of Appeal at the moment, which are not lots, but are rather dry and very specific to the particular issue the parties are involved in. So I haven't touched on those. You've heard someone talk a bit today about the Cronin Lamp, or maybe a couple of people, the Cronin Lamp case. That's now before the Court of Appeal. That it was, as you would have heard, of course, Hannah say, a case where remedies of 1.8 million were awarded to two individuals plus costs of circa just under $600,000. And it looks like the Court of Appeal has had a look at that and thought this is an awful lot of money for the Employment Court to be awarding them remedies. We want to have a look to see if they got the approach right. That was an interesting case and is an interesting case because it deals with not just your standard remedies, lost remuneration, hurt and humiliation, and the like, but also economic loss remedies such as loss on relating to sale of a rental property, loss in rent somehow arising from the employment relationship, and medical costs and the like. So it dealt with some interesting issues which are not standard remedies which are addressed in the Employment Court, but in the Employment Court deals with cases like that. As lawyers, we can expect to see some of these economic loss claims starting to filter in through claims being raised in the Employment Relations Authority. Green and Prime Resources is an interesting case from a legal perspective, and one that can come up, and that's a situation where there's a dispute as to interpretation of a clause in an employment agreement and whether an employee can also raise a personal grievance in relation to that disputed clause. The Employment Court has said no. There's a difference between a dispute and a personal grievance. The Court of Appeal is not quite so convinced, or not so convinced as to think that it doesn't deserve consideration by the Court of Appeal. And of course, the Gloria Vale case, that's just going to go on, and we'll talk about that next year as well. So I put it up there because everyone's seen the documentary. So that's still making its way through the Court of Appeal, the Supreme Court, the High Court, and who knows where next. And I understand also that the Susie Wiles case is, at least they've filed application to the Court of Appeal to appeal the case. That's Susie Wiles, she won. So I'm interested to know what she's looking to challenge, probably wanting more money. I'm not sure if that's been heard yet, so I'm not sure if that's going to be granted leave. We will wait and see, but if it is, that's a case that raises very interesting issues which have broader impact. So I'm conscious that you've been fed a lot of information today. If you're like me and over the next day or two you think to yourself, what was that really interesting point that ICRA made I've forgotten, or geez, Jaya gave a really good 10-minute presentation, but I've forgotten that really important point about AI she raised. I'm led to believe that we will be sending out the PowerPoint. So you will get that presentation, I believe. If that's not happening, you can ring up and say, well, David said it's happening, so can I please have a copy of that? You will have all of that information. You don't have to retain knowledge of everything that's been presented to you tonight. I'll quickly thank all the staff for what they've done. I think they've been excellent. That's my personal view, but I'm biased. So well done for the staff. I know a lot of you've put a lot of effort into preparing to present an excellent product to you tonight, and I can say I appreciate that, and I'm sure I'm speaking on behalf of all the other partners in saying that. Well done, you're a credit to us, and we wouldn't be who we are without you. So that's enough from me.